Hi, this is Julie Beavers with Ayers House Properties, and tonight I found a topic, some interesting tidbits on a topic: how divorce issues affect real estate. I got this information from a title company in the Valley, and there are four little different segments. The first one is, I got the house in the divorce, but did you really get the house? In the property settlement, you may have been granted to retain the home, but do you really have a clear title? The judges have authority to grant the title, but the wording in your divorce decree is very critical. If in the divorce decree the judge granted you title, then you have the legal title, and your spouse is not on the title and you have the home. But if the judge in the wording says you have been awarded the home, that kind of says you have the right to be the only person on the title, but it doesn't grant it that way. You have to get a deed from your ex-spouse that he is then giving away the interest into the home, and then you are on the title. Let's see. The next one is, can I buy a home before my divorce is final? Yes. Arizona is a community property state. There are times where someone, a married partner, wants to buy property and they want only their name on the title, and that can be done. The other person in the relationship has to sign a disclaimer deed waiving their interest in the property. Lots of times when divorce, emotions are high, and it may be difficult to obtain the disclaimer deed from the ex-spouse. In Arizona law, the divorce action if the divorce action has been properly filed and legal service of divorce papers can be documented, then no disclaimer is required. However, if the divorce is not finalized and there is no divorce, then both parties become subject to the title of the property, and it goes back to the Arizona community property laws. Another issue, my name is on the mortgage, but my ex-spouse got the house. Am I responsible for the loan? Absolutely. Lender made the money to two buyers on that mortgage paper, and you are both responsible for that mortgage. The ex-spouse, if the ex-spouse who has the house defaults on the loan, and then you can still be held liable for all the funds, all the deficiency after a foreclosure. You can petition the lender to release you from the mortgage loan obligation, but they usually are not inclined to do that. The last one is, my ex-spouse is no longer on the title to my home. Why is his or her debts posted as liens against my property? Is this valid? Possibly. Many liens incurred by individuals can be assessed against any real estate they own. If your spouse had a judgment or tax lien against them during the time they were with you or were entitled on the home, then that lien can still be on that property. If the spouse's interest was not properly conveyed in the public record, their liens can attach to the property as it is. And so, yes, the lien can still be on your property, on your home. Getting a divorce is a hard time. It's stressful, it's emotionally charged, and it's sometimes you're not always thinking about what the best possibilities can be for your home, for your real estate. So please, I am not a lawyer. These are some general information, but you need to get a lawyer that will take care of your interests in real estate, in the divorce, and do what's best for you. Thanks for joining me this evening, and hope to see you again on Heiress House Properties.